Okay, start. All right, good afternoon, gentlemen. So we'll continue with our class on practical law today. And the topic we're going to be discussing today is a conclusive part of a trial. And then after that, we'll go into trial proper. So recall that on the last date, I did discuss the issue of pretrial, what it entails, starting from the moment when pleadings are exchanged, the number of days open for the claimant to make application for pretrial notices to be issued and served on the other parties. And when he fails to do that, the defendant can also do that, but the defendant also has the option to cause the matter to be dismissed. We talk all about that. So today we are going to, we also talked about what the court does at pretrial stage. Then to conclude it today, I also want to point out that at the pretrial stage, all the applications pending at that very stage would be trashed out. It would be all the application would be heard by the honorable court within that period. And maybe possibly that is why the period of about 3 months is assigned for pretrial proceedings in accordance with the rules of practice and procedure of High Court of Abia State. But nothing stops a party from bringing a motion after the pretrial has ended, but such applications would have to be brought pursuant to the leave of the court. So you have to seek the leave of the court before bringing it. So talking about applications, there are two things I want to point out. Applications at this stage must, the applicant must ensure that the prayers in his application are not exactly the same as the claims in his substantive suit. Why? Because the court is enjoined not to determine at interlocutory stage the main issue in the claim. So there's a way a prayer will be couched in an interlocutory application that if one does not look at it carefully, it will end up being a granting of the main substantive relief sought in the claim. And that's why courts will be at liberty to refuse such applications that have the tendency of determining the substantive matter at the interlocutory stage. Now, having said that, we also need to talk about where there are multiple applications. Where there are multiple applications, the courts are also under the duty to painstakingly take each application and determine it on its merit. So it would be wrong for the court of law to handle multiple applications at the same time and then give ruling. By so doing, definitely it will affect the fundamental right to fair hearing of the party who will be prejudiced by the ruling of the court. So to this in support of this fact, I want to cite a recent Supreme Court case that has come out to say that the courts do not have the powers to determine multiple applications at once. And he's talking about the case of Oyetola against INEC. Oyetola against INEC. This case is reported in 2023, 11 Nigerian Weekly Law Report, part number 1894 at page 125. Here the Supreme Court said, where a court lumped several applications together without considering each of them on the merit and dismiss them, it would violate the fair trial of the applications and the right of the parties to fair hearing. You know, most of the time the court may be so much inundated with so much activities many applications that possibly the court is also looking at time, especially in election matters, that most of the time the court or the tribunal will fall foul of this very law or rule or practice. What a court is expected or a tribunal is expected to do in an instance where it is faced with multiple applications is to painstakingly, like I have said, determine each application on its own merit, not to handle the entirety of all the applications at once and either dismiss them or grant them. So the Supreme Court has said for such a thing to be done amounts to a violation of the fundamental rights of the party who has suffered prejudice. Now, like I have said, all interlocutory applications and every applications by way of motion on notice or ex parte are to be entertained at the stage of pre-trial. Now, after the stage of pre-trial, when the court has scheduled the trial and has written its report, the report that will contain like the scheduling, for instance, stipulating that the claimant is going to call 10, 15 witnesses as the case may be. The claimant will tender document as being the outcome of the pretrial proceedings itself. And then the court can also schedule the days of trial, maybe giving multiple days for the claimant to prove his case and close, and then other multiple days to the other parties to also open their defense and close. Then, after that, the stage would be set for trial. The stage would be set for trial. Before going into trial, there are a couple of things a party should be concerned with. First of all, you must be sure that you have gathered your evidence. You also must be sure that you have front-loaded all the evidence of the witnesses which require to be front-loaded. I'm also going to talk a bit on this in the course of this discussion, and then possibly cite one or two cases. And then also again too, this is a time that the lawyer will sit down with his client and plan his case properly. So he has to plan his case properly so that he will give the best of services to his client. So to this effect, I want to look at the case of VP Industries Limited. VP Industries Limited against OF Nigeria Limited. VP is spelled VEE PEE Industries Limited against OF Nigeria Limited. Reported 2023 9 Nigerian Cooler Report, Part 1889, page 279. The Supreme Court had something very, very important to tell counsel preparing case for his client at this very stage. Now, let's look at what the Supreme Court said. Page number 279. What the Supreme Court said about preparation of the case of the claimant or of the parties as the case may be. In this case, the Supreme Court, the Supreme Court commented on the need for a party to prepare his case properly, and that's talking about the advice of Ogunwumi JAC at page 313, paragraph F, where he said, This just action for recovery for this just action to recover money. I think it should have been this is just an action to recover money for goods admittedly supplied, which was instituted as far back as 31st of October in the year 2000, more than 22 years ago. Cases are lost are won in chambers where proper preparation must be undertaken before the action is filed. In other words, the Supreme Court, by this dictum, is simply advising counsel and parties. Counsel your clients, sit down in your chambers, plan this case properly, find out the weakness of your case and the strength of your case. By that, you'll be able to present and represent your client appropriately, even if in the end you lose the case. At least your client will be happy that you did all you could, but that the case went against him. So long as the case is not lost based on negligence. Right. Trial proceeding will depend on the nature is filed. It will depend on the nature of the case filed. So I want to first of all consider an action filed by way of originating summons, which naturally, like we have stated in the course of this discourse, that it takes a different pattern. Now, if our action is an action that is predicated on originating summons, there wouldn't be anything like pretrial proceedings. There won't be anything like pretrial proceedings because in originating summons, it is presupposed that your action is not contentious. And not being contentious, there won't be any need to go into pretrial scheduling and all those processes that are done at that very stage. But being an action founded on originating summons, you are simply inviting the Honorable Court to interpret either an instrument or a statutory provision within the purview of its jurisdiction with respect to originating summons. Now, let's assume that what we have faced now is originating summons. How is it heard? How does the hearing process commence? In an originating summons, after it has been filed by the claimant who has posed some questions for the determination of the court, the other parties concerned will simply file a counter affidavit where they differ, especially on point of facts, where they differ on issue of facts. Remember that most of the times it is the fact that you usher in the document that you want the court to interpret or the law that you want the court to interpret. The facts will be able to state whether that law applies to you or whether it does not apply to you. And that's why the other party may simply file a counter affidavit to show that what you seek to the court to interpret does not apply to the case at hand. Doesn't apply to the case at hand. And also remember that your suit must be proper before the court. And then originating summons basically depend on the provision, that's the procedure for commencement of the hearing, basically depend on the provisions of the High Court civil procedure rules of the particular state in question. So I want to cite an example of a decision of a Supreme Court with regard to originating process commenced at the Federal High Court. This is the case of B. Song against Ochinke. Bisong against Ochinke. Bisong Besong against Ochinke. This case is reported in the year 2023, 7 Nigerian Weekly Law Report, part 1884, at page 545. Now, talking on when action may be commenced by originating summons and what court determines therein, the Supreme Court stated, taking into view the court where the action was brought as well as the rules of that very court. And the Supreme Court said, by virtue of Order 3, Rule 7 of the Federal High Court Civil Procedure Rules 2019, a person claiming any legal equitable right in a case where the determination of the question whether such a person is entitled to the right depends on a question of construction of an enactment, may apply by originating summons for the determination of such question of construction and for a declaration as to the right claimed. Two things, I'm going to explain them. The questions set out are those upon which a claimant's rights depend. A court is not to go outside the questions submitted, and the relief sought to create a separate cause of action for the plaintiff. And then, referring it to the case cited, the Supreme Court said, in the instant case, from the questions of relief sought by the appellant, the grievances of the appellant was based on the primary election held on the 23rd of May 2022. Nowhere in the question and reliefs was any mention made of the rerun election of the 4th of June 2022. The Court of Appeal was therefore right when it looked at the appellant's originating summons in deciding that the appellant did not mention the rerun election. There are two things I brought out from this decision of the Supreme Court I said I'm going to explain. The first one is that originating summons is brought by the plaintiff instrument or provision of a law. And in his originating summons, what he is expected to do is to couch questions that will touch on his rights, so that if the question is answered, depending on how it is couched, if it is answered positively in his favor, it will mean that he actually has rights subsisting under that document if constructed in his favor. And he does not stop by simply couching questions for the determination of the court. He will also have to seek for reliefs. In other words, the reliefs must be ancillary to the proposed answers he has in mind, flowing from the questions posed in the originating summons. In other words, the relief must not be incongruous. It must not be adverse or directly in opposition to the questions he seeks the court to answer. So simply put, the reliefs must not constitute a different cause of action, different from the questions posed in the originating summons. In other words, his cause of action depends on the question that he has couched, and his capacity to so couch them to favor him is what will persuade the court to look at the provision and answer whether it favors him or not. And then also, if the plaintiff has added anything in the relief sought that are not in consonance with the questions asked, the court can do what? Overlook it, discountenance it, just like the Supreme Court stated in this very case. And then one other thing I want to bring out from the Supreme Court decision in this cited case is the ratio where the Supreme Court said that the entire reason for setting out questions for determination in an originating summons is for the court to be guided by those questions. That's why I talk about the capacity, your capacity to make the question to be persuasive enough for the court to look at it and interpret it in your favor, depending on the provisions of the law and your ability to have brought yourself within the purview of the provisions sought to be constructed in your favor. The questions are the compass that ought to steer the court in the right direction, just like we have stated, so that it does not veer off the dispute submitted to it. You wouldn't, if for instance, maybe you were a woman, a female child in Abia State, and knowing fully well that there is this law, Abia State law on female inheritance of property, and then you have been married out of your father's house, but your father has a house, and maybe at the death of your father, your siblings want to sell the property and share the money, and you want to, show that you should have a share, that you should have a claim. So you couch your originating summons, your lawyer will couch it. Looking at the provisions of that law, is a very short law, especially provision of section 6, 7, 8, 9. Looking at it and finding out how the question will be couched to favor you. For instance, whether as a daughter of Mr. A be deceased, the plaintiff or the claimant, as the case may be, is not entitled to inherit from the estate of her late father pursuant to section 8 of so law. That is how to catch it in such a way that your right will be visibly seen and it will be persuasive enough. In other words, from the example I've given, this lady has been able to show that she's a female child good. She's a daughter, one of the daughters of a late person, and that the property, the estate of this person is maybe up for sharing or up for distribution. And in her question, she is asking whether as a child she's not entitled to inherit, despite the fact that she's married though, out of the family. But what is giving her the power, the right, is pursuant to section so law. So she wants the court to construct the provision of that very law to admit her as one of the beneficiaries of the late father's estate, despite the fact that she has been married outside the family. Now, after that, let's look at other cases, maybe cases commenced by originating by writ of summons. Originating summons, like we have said, the court will look at the processes and then whether even if the other party fails to file a counter affidavit, since it's construction, the court will look at it and then interpret it the way it is urged to interpret it, and interpret it either in favor or against the person who is claiming under such provision. But under the writ of summons, we have a contentious case at hand. And the first thing, like we have said, a case is won or lost by the kind of preparation that a counsel, has made with his client. And then apart from that too, a party has to be consistent. A party has to be consistent with the kind of case he wants to present before the court. It has to be consistent. Not, for instance, when the writ of summons is talking of a different thing, our relief will be saying a different thing altogether. And then in the end, when the matter is lost, you begin to wonder whether the judge took bribe. You will be shocked to know that no judge took bribe in your matter, but it was a question of lack of adequate preparation that robbed you of that very victory in that very case. So to this effect too, I want to also look at another Supreme Court decision which is predicated on a party being consistent with the case he is making out before we now look at the rules guiding the trial procedure itself. I'm talking about the case of PDP against Uche. PDP against Uche. This case is reported in the year 2023, 9 Nigerian True Law Report, part 1890, at page 523. At page 523. So just permit me to open the relevant page so that we can hear what the Supreme Court said about a party being consistent with the case he is pursuing in any court of law. That's talking about PDP against Uche. So just a few minutes, let me get to the page. Right. So we'll find this ratio at pages 600 to 601, paragraph C to B of that very decision of the Supreme Court. Here the Supreme Court stated thus: a party is mandatorily bound by law to consistently maintain and pursue the prosecution of the case he filed in court throughout all the stages of the hearing of the case, even on appeal to the Court of Appeal or a further appeal to the Supreme Court. What does this entail? He cannot change a case to a new one at any stage of the hearing. He is not permitted to do so. A party must consistently make his case and not change his case at different stages of the hearing. He will not be allowed to check one position in his originating processes and then turn around and take a different position at a later stage in the case. And then in reference to the case cited, the Supreme Court noted that in the instant case, the first respondent by his reply affidavit made a case diametrically opposed to the case he brought in his originating processes for determination by the court. By the reply affidavit, he sought to change his case midstream to defeat the objection that his suit as constituted in the originating summons was statute barred and to bring the case within the provisions of Section 33 of the Electoral Act 2022. So one may want to ask, what causes inconsistency in preparation of a case or in presentation of a case? It also boils down to improper preparation, improper conferencing with your client. You need to sit down with your client, find out the weakness of your case, the loopholes, perceived loopholes, because once you file it, the opposition will hit you if they notice that. So when you have realized the weakness of your case, that's when you ask yourself the proper questions. How do you repair the damage? How do you go about it? Which way would be better to present this case? What options would be better for us? Not when you have started by saying that the land belongs to you by purchase. And then in midstream, you now start to change your case to show maybe the land was gifted to you. That would be a party being inconsistent in his case. Well, of course, the consequences are very clear. That case will definitely be dismissed because it is self-defeating and diametrically opposed to each other, as the Supreme Court has said. So now we go down to the trial proceeding. We are taking the rules of Abia State High Court as a guiding instrument in this very lecture. I'm talking about the Abia State High Court Parties and Procedure Rules 2021, which most of the provisions are not different from most of the provisions you find in the High Court Civil Procedure Rules of other courts like Rivers State, Imo State, Lagos State, Federal Higher Capital Territory, and so on and so forth. Because by the time these rules were made and signed by the Chief Judge, all those other rules were consulted to ensure that at least most of what we are doing here would also be similar to what is obtainable in other states of the Federation, so that we do not begin to run laws or practice laws that are in the opposite direction against what some other states are practicing. So the provision that talks about trial proceedings under Abia State Practice and Procedure Rules 2021 is Order 30. Order 30. Now, Order 30 has a lot of steps that must be taken, things that must be done, or things that the court will do if certain state of things do exist or do not exist. First of all, we talk about non-appearance of both parties. Where the case is ripe enough for hearing and none of the parties appears, what will be the attitude of the judge? So the attitude wants to play that when a cause on the cause list has been called up for hearing and neither party appears, the judge shall, unless he sees good reason to the contrary, strike out the case. The court shall strike out the case unless the court sees good reasons to the contrary. Now, when the court decides to take the first measure, which is that of striking out of the case, the court is simply saying that parties have abandoned the case, especially the claimant who brought the matter to court. It's simply talking about parties not being interested in the matter. And then again, the rule says that the court may decide not to strike it out if the court sees good reason to the contrary. In other words, there is a discretion here to be exercised by the judge. A lot of things can inform the mind of the court not to strike out the matter. For instance, the court may simply say, okay, this matter is coming up before me for the first time. That would be good enough reason to say, okay, let's adjourn. The judge may also want to find out if all the parties in the matter have been served. If maybe there is no proof of service, the court may either strike it out or say, okay, let's give them one more time. And then also, there may be some supervening event that occurred before the hearing of the day. Let's say, for instance, there was a strike action either by, Juson or Nupeng, any type of strike action at all. that disrupted activities in the society immediately preceding the date for hearing. That would also be good reason for the court to say, okay, let's give them time, but then the court cannot just adjourn just like that without taking further steps. What will be the further steps? The further steps will be the court making an order that hearing notices be issued and served on the parties so that the parties will know the next adjourned date so that the parties will be present in court before the next by the next adjourned date. Now, there is a decision here on the effect of the order striking out a suit. Let me read the decision of the Supreme Court. Decision of the Supreme Court in the case of Allied International Industries Limited. Allied International Industries Limited against EcoBank Nigeria Limited. Against EcoBank Nigeria Limited. Against EcoBank Nigeria Limited. There are a lot of things that we will learn from this decision of the Supreme Court. First of all, let me read out what the Supreme Court said about the order striking out a suit. The Supreme Court said, an order striking out a case only keeps the case in abeyance, which means it doesn't terminate the case. It just suspends the case. The case will be hanging somewhere. It's just like when you make a transfer and it doesn't go instantly, or you send SMS message to somebody and it's not delivered immediately. So it is suspended. So when a suit is struck out, the effect is that it is suspended, it is in abeyance. Such a suit can be released once the proper application and reasons are advanced. So when your case is struck out, you have the right to make an application for the suit to be released, and in your application you also have to advance reasons, and these reasons must be reasonable enough to convince the court either maybe, my lord, we were not served, my lord, we were not aware, my lord, that very day we were coming to court and we heard that day was sit at home and everybody was afraid we couldn't make it to court. Any reason that is responsible for you not to be in court that very day will be looked at by the court. Right. Now again, I did talk about the issue of service of hearing notice. If a party or the parties do not appear and the court feel that there's need to give party one more time to appear before it, the court may adjourn the matter and then make an order for hearing notices to be issued and served on the parties, intimating them on the next adjourned date. The Supreme Court in the same case here said, failure to serve a party to a case with hearing notice where necessary and required by the law in line with the constitutionally guaranteed right to fair hearing automatically vitiate the proceedings of a court of law as well as all the outcome thereof on the ground of breach or violation of that very right. So when a party has not come to court or failed to come to court and there is need for the court to adjourn the case, the court must also do what? Make an order that hearing notices be filed and served on that very party. Even if a step is taken, maybe the court say, okay, plaintiff, since the defendant is here or claimant, go into the witness box, call your first witness, and then I will adjourn for cross-examination on the next day. The court must also make an order the hearing notices be served on the opponent so that the opponent will know that the next date will be for him to cross-examine the witness. But where such is not done, everything done in that proceeding becomes what? Null and void. Because it will be said to have done what? Violated the defendant's constitutionally guaranteed right to fair hearing. So we look at another instance under Order 30 Rule 2. Order 30 Rule 2 talks about default of appearance by defendant at the trial. And it says, when a cause is called up for hearing, if the claimant appears and the defendant does not appear, the claimant may prove his claim so far as the burden lies upon him. This is one of the things the court can do. But when we look at this rule, we discover that it appears not to have given any discretion to the judge. But that does not mean that the judge, as the presiding judicial officer who ought to be impartial, an impartial umpire, cannot exercise any discretion. The court may still refuse to comply strictly with this order, which means, not, let me not talk about, use the word refuse. The court may not apply strictly the provision of this order. In other words, the court may not simply ask the claimant to go into the witness box to prove his case in the absence of the defendant, except there is reason enough for the court to believe. So, right, like if the defendant has been fond of absenting himself from court, or the court has looked at the file and discovered that there is a affidavit of hearing, proof of service, affidavit of service, and the court believes that the defendant was aware of that very date. That may be when the court may say, okay, claimant, since the defendant ought to know that this matter is coming up today, go ahead and prove your case. And then Order 3003 talks about default of appearance by claimant. Default of appearance by claimant. Remember the first one, Rule 1 is where both parties fail to appear. Rule 2, where defendant failed to appear. Rule 3 is going to handle situation where the claimant himself has failed to appear. And it says, when a cause is called up for hearing, if the defendant appears and the claimant does not appear, the defendant, if he has no counterclaim, shall be entitled to judgment dismissing the action. Shoot this in a bit for me. Let me put this on the floor. Shall be entitled to judgment dismissing the action. But if he has a counterclaim, I'll use it later. If he has a counterclaim, then he may prove such counterclaim so far as the burden of proof lies upon him. Now you discover that there is a relationship between Rule 2 and Rule 3 here, and so that what we said with respect to Rule 2 also applies to Rule 3. So nothing stopped the court from looking into the case file to find out whether there is any reason why the claimant failed to appear in court. And nothing also stopped the court from applying that provision of the law strictly. In other words, to give both parties a fair level playing ground, and also to ensure that the opportunity for fair hearing has been provided for the claimant, in as much as he's the person who instituted the action. All right, so we'll go further to another provision of that. And mind you, there are also decided cases on this. That's why I say it all depends on the provision of the rules of court of any given state. So I will look at Rule 4. Rule 4 has 3 sub-rules. Rule 4 is talking about judgment by default. Judgment by default. I will also, by the time we start discussing judgment, maybe I will also touch this once again. It says where a cause is struck out under Rule 1 of this order either party may apply that the cause be replaced on the cause list on such terms as the judge may deem fit. Remember, I cited to you the Supreme Court decision in Ecobank's case, where Supreme Court said that if a case is struck out, that case is where it is in limbo. It is at abeyance pending when the requisite application will be made. So this provision here is the right provision that entitles a party under the Abia State Statutes and Procedure Rules whose matter has been struck out to apply to have his matter relisted. Sub 2 said any judgment obtained where party does not appear at the trial may be set aside by the judge upon the terms as he may deem fit. Let's say, for instance, under Rule 2 of Order 30, the claimant was in court. He proved his case and he got judgment, maybe a summary, let's say he's talking about a case of liquidated damages or liquidated claim, and then the court gave him judgment. Because it is not a judgment on the merit, it is called a default judgment. The party who was affected by that decision could come under Order 30 Rule 4 Sub Rule 2 to make an application that judgment be set aside, and then the court will also exercise its discretion as to the terms of the setting aside. Maybe when the court looks at the entire facts of the case, maybe possibly discover that it was not the fault of the defendant, the court may even release the case without cost, without making an order as to cost. But if the court maybe notices lack of diligence on the part of the party against whom that default judgment was given, the court may still go ahead to grant the application to set aside the judgment, but on terms. The terms may be to pay cost to the other party who was diligent. And then we look at Sub Rule 3 of Rule 4. It said an application to release a cause or set aside the judgment shall be made within 7 days after the order or judgment, or such longer period as the judge may allow. There are 2 things you have to note here. If your matter is struck out, you have 7 days from the day the matter is struck out to bring an application for the releasement of the suit struck out. So if you have brought your application within time, there's no need to apply for extension of time. You simply bring an application motion on notice seeking the order of the court to release suit number so, which was struck out on so date due to the absence of the defendant. And then in the affidavit in support of the motion, you begin to have facts that will show reasonable grounds why the court should exercise its discretion in your favor. But if you got to know about this after 7 days has elapsed, that means you're out of time to apply for releasement of your suit that was struck out, in which case your motion is going to contain at least 2 prayers. The first one would be for an order of extension of time for you to apply for the suit number so to be relisted, and then again order of the court relisting suit number so which was struck out on so date for the absence of the defendant. The same thing applies if what was delivered was judgment. You have 7 days to apply for the judgment to be set aside on the ground that the judgment was a default judgment, and you give your reasons why you defaulted. And if your application is coming after 7 days, you also seek an application for what? Extension of time. Now, adjournment of trial. Rule 5. The judge may, if he thinks it expedient in the interest of justice, postpone or adjourn a trial for such a time and upon such terms as he may deem fit. Let's say, for instance, remember that at the pre-trial session, the court had already scheduled how a party would present his cases. But then we also remember that we are all human beings and that maybe we may propose something and nature will dispose it. Maybe if you have planned that the matter ought to have been heard yesterday and yesterday something happened that made it impossible for the state to work, that will be taken into consideration. Or the judge, as a human being, might be indisposed. That will also be taken into consideration. Or if a matter is proceeding to trial, the claimant, you have fielded like one or two witnesses, and the third witness is not present in court. You make an application to my lord, giving reasons, which may be maybe the next witness that you ought to call to come and testify is a civil servant who could not make it today, or is somebody who is coming from outside the state and was not able to make it to court today, and you are seeking my lord's discretion to adjourn the case to any day that will be convenient to the court as well as to your learned friend on the other side. So that is talking about adjournment. It is purely at the discretion of the court, but it is a discretion that when exercising, the court must bear in mind that granting or refusal of such an application has to be anchored on the interest of justice. So when you're making the application, the other party may be opposing, and the judge will be asking himself, how can interest of justice be better served? Is it not just to allow the party? No problem. Let's give him one more time. Let him come and prove his case. Let the matters be heard on the merit, so that in the end, judgment could be given one way or the other. And then there is also a provision for time of commencement and of trial. Time for commencement and trial. Rule 6 says that the registrar or other designated officer present at any trial or hearing shall make a note of the times at which the trial or hearing commences and terminates respectively, and the time it actually occupies. On each day it goes on communication on the taxing officer if required. So this provision here seems to apply basically to tax matters. And then also when we talk about the registrar here now, you're also making reference to the clerk of court. We normally call them clerk of court, but most of them by positions are also registrars of court. So the duty of a registrar of court is to do endorse the case file. The case came up so day is adjourned, because when the court, the clerk of court normally prints out the course list, all the cases that will be handled on that very day. If matter number 1 has been handled and adjourned to, the clerk will write the date. If not, matter number 2 was struck out, the registrar will write struck out on, so that there will be a proper record. I remind you that this record we are talking about is a public document, which any member of the public can also make an application to get a certified true copy of it, depending on what need he wants to satisfy with it. Then Rule 7 says, order of proceedings at the trial of a cause shall be prescribed in the following rules. We've already talked about pretrial. I think pretrial provision has already overtaken the provision of this Rule 7. The party on whom the burden of proof lies by the nature of the issues or questions between the parties shall begin. So remember your law of evidence. We did talk about the party who has the onus of proof. Not necessarily, it may not necessarily be the claimant. It depends on the issues at stake. It depends on the kind of case that you have brought, and it also depends on the state of pleadings. So the onus of proof will lie on that party who will lose the case if no further evidence is adduced on the other side of the divide. And I did give an example. Let's say somebody has sued for a declaration of title to land, and he is predicating his case on the ground that the land belongs to them by inheritance. And then the defendant, after having seen this, files his statement of defense. Maybe in the statement of defense, he said, no, this land does not belong to this person. It no longer belongs to the claimant by inheritance. He may admit that the claimant ought to have inherited the land, but the father of the claimant sold it to him. You discover that there is nothing for the claimant to talk about there. There is no live issue for him to prove there. Why? Because by the nature of the pleading, state of pleadings, the defendant is the person who has raised the live issue that is capable of determining the entire issue, the entire suit. He agrees that the land belongs to the claimant's father, but he sent the claimant's father sold it to him. So he now has the proof to do, the onus of proof to do what? To prove that he bought the land from the claimant's father. So the claimant simply stays there to listen. Maybe the claimant didn't even know that the father sold the land. So that's why I say there is no live issue in his case, again, depending on the nature of the state of the pleadings. So that's what this provision is talking about. That rule, that general rule, burden of proof, will lie on that party who will lose if that issue, if no evidence is adduced to prove that particular issue or claim that is capable of determining the entire suit. We now say documentary evidence shall be put in and may be read or taken as read. Like I did say when I was talking about pretrial proceedings, at the level of pretrial proceedings, documents may be tendered. I say may be tendered depending on the course that the judge, as the master of his court, has adopted during the pretrial. The court may decide, I will entertain tendering of documents and objections at the trial. Most of the time, that is what judges do, and that's also what counsel agreed to do. Because at that very time, when the trial is going on, because at the pre-trial level, you are not looking at the pleadings. You are simply looking at the answers, pre-trial questions and answers. So for me, it would even be wrong to start tendering, raising objections, and making ruling at the stage of pre-trial. It will be prejudicial. So that's why it is better to allow trial to proceed, and then parties will look at the documents sought to be tendered, and then look at the rules guiding admissibility, look at the pleadings to know whether by the state of pleading that document is admissible in the first place, or whether conditions precedent to tendering of that document have been complied with or not. All right. Rule 10 has two subs, so some of these subs I'm just going to paraphrase them, so that we meet up with our time. But mind you, we're discussing trial proceedings, right? A party who desires to call any witness, not being a witness, whose statement on oath accompanied his pleading, shall apply to the judge for leave to call such witness. So I'm going to explain the purport of this very provision. This is because by the practice most states of the Federation, or all the states of the Federation, have adopted is that of front-loading of documents. So that any witness you intend to call to come and testify in court must file his written statement, he must have his written statement on oath attached to the bundle of either your originating processes or your statement of defense. But if peradventure you have any witness you want to call whose name was not listed in the list of witnesses, it does not mean that the law has foreclosed you. This is like a second chance. Under 30 Rule 10 sub Rule 1 has given you the opportunity to seek the leave of the court. Bring an application, and this application is a post-pretrial proceeding application whereby you're also going to seek for leave to bring the application and then the leave of the court to enable you bring another witness whose name was not originally listed. So for this, let me give us an authority, say something on written deposition, on the importance of front loading, what the court has said concerning front loading of the evidence of a witness, what the Supreme Court has said concerning front loading of the evidence of witness. This is the case of Sokoto against INEC. Sokoto against INEC, reported 2022, 3 Nigerian Weekly Law Report, part 1818, part 1818, page 577. Page 577. Now, the Supreme Court stated that the front-loaded deposition on oath of a witness, that's written statement on oath of a witness, in support of his pleadings, constitute his evidence in chief in the proceeding. In other words, when you start calling witness, it's not coming to enter into the witness box to start telling stories. He simply adopt. We're going to also look at that. He simply adopt this is written statement on oath. So when there is no witness so listed and no written statement of that witness attached, what you simply do is to seek the leave of the court. You seek the leave of the court to introduce the witness, and then you also front load the written statement or the position on oath of that witness and serve the other party. And then the Supreme Court went ahead to answer the question whether pleadings constitute evidence. And he said, no, pleadings do not constitute evidence. What constitutes evidence are the written depositions on oath of witnesses in support of the pleadings. In support of the pleading. So you can also look at the case of MTN Nigeria Communications Limited, MTN Nigeria Communications Limited against Corporate Communication Investment Limited, Corporate Communication Investment Limited, Corporate Communication Investment Limited, reported 2019, 9 Nigerian Weekly Law Report, Part 6. The sub paragraph 2 of Rule 10, Rule 10, that's Rule 10 sub paragraph 2, which stipulates that an application for leave in sub one of these rules shall be accompanied by the statement on oath of such witness. So when you are seeking leave of the court to allow you bring the witness whose evidence you did not front load with original or originating processes or statement of defense. When you are making the application, you must also file alongside the written statement on oath of that very witness so that the court will know what that party is coming to say. And then the opposition will also not be taken by surprise concerning what that party will be coming to say. And then we also have Rule 11, which deals with dispensing with oral testimonies. And it states that in any proceeding before the court, parties may, by consent, at the close of pleadings, agree to a trial or records where they rely only on the documents and exhibits front-loaded and thereby dispense with need for oral testimony and cross-examination. This is rarely the case, or it rarely occurs, but it is still possible. What this page is talking about is that where the case is purely documentary, parties are relying on documentary evidence. Parties may agree on consent. Let me just tender our documents, let the court examine the documents, especially if, for instance, it's a case where the court needs to determine the priority of title. Let's say we have two contending interests over title to land. I'm saying I bought, and the defendant is also saying he bought the land and he has bought his document, and I have also brought my document because it is purely a legal issue, especially based on the rule of prior extempore. So what the court will simply do when parties have agreed, so look at it, who bought first, as per competing legal interest, the first in time prevails. And if, for instance, the interest is between legal title and equitable title, of course, the legal interest will prevail. So in that case, you don't even need to bother yourself calling witnesses. Just go ahead and rely on the documents tendered before the court. Rule 12 talks about close of case of parties. A party shall close his case when he has concluded his evidence. Either the claimant or defendant may make oral application to have the case closed. It's simple. When, as a claimant, you have 3 witnesses or 4, and you have gotten them to testify, once each of them will testify and be cross-examined by counsel on the other side. So if you have a re-examination to make, you make re-examination. But if there is no re-examination, you just continue doing that until you have dispensed with all the witnesses. After you have discharged your witnesses and you have no more witnesses, okay, just inform the Lord. My Lord, this is the case of the claimant. In other words, the claimant hereby closes his case. The case of the defendant takes also the same pattern. When the claimant closes, defendant starts calling his witnesses. They will testify, cross-examine, re-examine if need be. Those who have documents will also tender. When he is done with all the listed witnesses, he also apply, my Lord, this is the case of the defense. May the defense close his case. It is taken that case has been closed. And then all those documents tendered at the trial are called exhibits. There are other things that may be tendered at the trial that are not exhibits, things that are different from that are not documents, things that are different from documents. Let's say, for instance, a gun was tendered and a machete was tendered, cassava was tendered, any other material whatsoever. Those things are, if so long as they are admitted, they are called exhibits. And Rule 13 deals with the exhibits during trial. And it states that the registrar shall take charge of every document or object, just like I have said, put in as exhibit during the trial of an action, and shall make or label every exhibit with a letter or letters indicating the party by whom the exhibit is put in, or where more convenient, the witness by whom the exhibit is proved, and with numbers, so that all the exhibits put in by a party are numbered in one consecutive series. If the claimant had tendered 3 documents, it becomes the duty of the registrar, that's the clerk of court. Normally, when we tender original, you make an application to substitute with a photocopy because you wouldn't want to deface or assuming you have tendered your certificate. Once you write anything there and you have defaced it, you have forged it, it has become forgery. There could be a lot of legal effect on that. So that is why when you tender original document, you apply to have it substituted with a photocopy. Now, on the photocopy, the registrar will write document tendered by claimant if it is the claimant directly, or claimant witness 2, CW2, and admitted as exhibit B. You just mark it in red and keep, so that when the judge will be sitting to write judgment, all those exhibits will be brought to the judge, and the judge will consider them one after the other, so that it will be easy to know the exhibits tendered by the claimants and the witnesses, as well as exhibits tendered by the defendant and his witnesses. Then, apart from that, the duties of the registrar in this regard includes the following. The registrar shall cause a list of all the exhibits in the action to be made. He will just draw a list of the exhibits. The list of exhibits, when completed, shall form part of a record of proceedings. For the purposes of this rule, a bundle of documents may be treated and counted as one exhibit. Let's say, for instance, is a matter where multiple documents have been tendered. Documents that have the same character or have the same are rooted in the same transaction. Maybe let's say things like receipt of this, receipt of purchase receipt. All those of them may be gathered together and treated as what? One document, as one exhibit, depending on the discretion of the judge. A witness by whom an exhibit is proved includes a witness in the course of whose evidence the exhibit is proven. All right. Written address by the party. When cases have been heard and closed, Rule 14 will come into play. Under Rule 14, when the party beginning has concluded his evidence, the judge shall ask the other party if he intends to call evidence. If the other party does not intend to call evidence, the party beginning shall, within 21 days after close of evidence, file his written address. So, in this scenario, if the defendant doesn't call any witness, then the claimant will just file within 21 days his final written address and serve so on the other party, who will also have the equal number of days to file his own written address. But under Rule 15, when the other party has called evidence, he shall, within 21 days after close of evidence, file his written address. In other words, where matter both parties call witnesses, the person to start to write his written address first is the defendant. He has 21 days to do that. After that, the claimant will also have 21 days. Most of the times, if a defendant fails to serve you as a claimant within the stipulated 21 days, as soon as his 21 days has expired, your time starts to count. So you can just write your own. If he doesn't bring any application for extension of time, or is not by any way allowed by the courts to bring in his written address after expiration of time, it means that you are the only person who has final address before the court. But we should also know that final address does not mean evidence. The purpose of final address is just to help the court summarize the case of a party, streamline the direction, supply authorities and issues which maybe the judge ordinarily may not advert his mind to, except when that address is written. And that's why it is said that the address of counsel, no matter how ebulliently couched, does not translate to evidence. It doesn't mean evidence. It doesn't translate to evidence. Upon being served with other parties' written address, the party beginning shall, within 21 days, file. So when the defendant is the first person to file within 21 days, then the claimant, 21 days after being served, will also file and serve his own. Now, when all these final addresses are filed and served, the next issue is who has the right of reply. It's answered by Rule 17 that stipulates that the party who files the first address shall have a right of reply on points of law only. The reply shall be filed 7 days after service of the other party's final address. Normally, when the defendant starts first, defendant serves the claimant. After 21 days, the claimant also file and serve his own, and then the defendant will read it, and within 7 days will reply only on points of law and not on facts again. So if he does not have anything to urge the court on points of law, he mustn't take or file anything if he has nothing to file within that time. This is also possible where the final address, the facts are interwoven. They are purely issues of law. So you may not even need the 7 days given to you here. Rule 18 talks about when exhibits are released after trial. And it says that an exhibit shall not be released after the trial to the party who has put it in, unless the period during which notice of appeal may be given has elapsed without such notice having been given, and then only if the trial judge, or in his absence another judge, grants leave to release such exhibit on being satisfied, A, that the exhibit will be kept duly marked and labeled and will be produced if required at the hearing of an appeal, or that the release of this exhibit will not in any way prejudice any other party. Sub 2, any notice of appeal has been filed. After any notice of appeal has been filed, an exhibit tendered at the trial shall not be released unless leave to release such exhibit is granted by the court. So what Rule 18 is talking about here now is that, as a general rule, exhibits tendered at the trial shall not be released to those who tendered it. Why? Because the other party may want to go and appeal. And that means that these exhibits are going to form part of what? The record of appeal, which will be transmitted to the appellate court. So that is why, as a general rule, the fact that the matter has ended does not mean that it has to be released to you. But if a party, maybe due to the nature of the exhibit, wants the exhibit to release to him, he can make an application for leave to the trial judge, showing reason why the trial judge should release the exhibit to him. And then, especially if the exhibit is a perishable one, it will be marked and he will enter into undertaking to produce the exhibit as and at when required. All right. So that is talking about exhibit. So the other things about exhibit here, I will talk about it by the time I will be discussing the appeal process. The appeal process. Then the next thing that we also need to touch, which other part of one is talking about, is filing of written address. Filing of written address. The order shall apply to all the application of final written address that we have said, and then what would be the contents. So to summarize it, a written address shall be printed on a good quality paper set out in paragraphs and shall contain the claim or application on which the address is based, a brief statement of the facts with reference to exhibit attached to the application or tendered at the trial, the issues arising from the evidence, a succinct statement of argument on each issue, incorporating the purport of the authorities referred to, together with full citation of each authority. Every address shall not exceed 35 pages for those who like writing bulky things. So every final address shall not exceed 35 pages, and every reply 15 pages. And at times you may not even need to write up to 8 pages because a reply is simply a reply and point of law, except maybe one is citing a case and trying to show the decision of the court by making quotations upon quotations. Most of the time, those things are not necessary. You just cite the case. If there is any particular statement of the court that is direct on point, you can call the attention of the judge to it in your final address. And then after that, you summarize it. When you summarize it, you conclude, put your address for service, and then file it and serve on the other party. And then at the adoption, that is when all the addresses are filed, Order 31 Rule 5 will come to play, and it says, when final written addresses or written addresses in respect of any application under these rules have been filed, and such come up for adoption, and either of the parties is absent, the court shall, either on its own motion or upon oral application by the counsel for the party present, order that the addresses be deemed adopted if satisfied that all the parties had notice of the date of the adoption. The court shall be satisfied that a party had notice of the date for adoption if on the previous date last given the party or his counsel was present in court. What this place is simply saying is that, quite unlike the old practice where maybe a party who was not present was not allowed to address the court when it was done viva voce, oral address. But here now, we are now doing our addresses through written, in written form. So whether the other party is in court or not, and the court is satisfied he knows that today is the date for adoption, he will just be deemed to have adopted his written address, even though he is absent in court. Why? Because that process is already before the court. And but where parties are in court, the court may still allow oral argument, oral amplification of the argument, and may, in the course of doing that, maybe just give you 5 minutes to do your oral adumbration, but nothing stops the court from telling you just adopt. So you just adopt, and that will be all. So there are other things that we need to know about trial, and we shall be taking that during our next lecture. And what I will be discussing during that next lecture will be some of those things that happen at trial itself, like a tendering of documents, the witnesses. We have covered them, we have covered the rules guiding them, but I would want to just make some side comments on them and possibly cite some cases during the next adjourned lecture date. So far so good. Thanks for joining us today. Do have a nice time. This one will also take like 2